SJC-12983, Don Desrosiers and others, v. the Governor of the Commonwealth.
Mr. DeGrandis.
Yes, thank you, Your Honor. May it please the court, I'm Michael DeGrandis with the New Civil Liberties Alliance, appearing on behalf of the petitioners in this case. Your Honors, the questions presented here can be succinctly restated as a simple proposition. May Governor Baker ignore a health statute that expressly provides for the containment of a pandemic, of epidemics, of infectious disease, and instead exercise the police power as he sees fit pursuant to a civil defense statute? The answer to that question has to be no. It has to be no if Article 30 separation of powers means anything at all, and if the Massachusetts government is the Republican form of government guaranteed to its citizens by the United States Constitution. The Civil Defense Act makes no mention of disease, and no disease, no pandemic has ever triggered a Civil Defense Act state of emergency. All prior states of emergency have been related to military preparedness, weather-related crises, and one instance of a natural gas explosion that set fire to at least 3 towns. The Public Health Act...
If I could interrupt you for a moment.
Sure.
I understand your statutory construction argument and the argument about the general being limited by the specific, but in the Civil Defense Act legislation, it specifically references protecting the public health. And when we look at other natural causes as a listed concern, and we see that one of the purposes of the Civil Defense Act is protecting the public health, why wouldn't that leave us with a reasonable statutory construction that the governor's acts are within the statute?
There are at least, I would say, 3 reasons why that wouldn't be a reasonable interpretation. First and foremost, we have the canon of adjustem generis, which requires that general phrase, other natural causes, to be limited to the preceding specific phrases, fires, floods, and earthquakes. There also would be no limiting principle whatsoever if every natural occurrence, because everyone agrees here that all man-made calamities, war, sabotage, terrorism, all of those fall into the Civil Defense Act. But if other natural causes means every natural occurrence of any sort, well, then there's absolutely no limiting principle. When can't a governor declare a civil defense state of emergency?
Well, this is not every situation. This is obviously a pandemic where the spread can be from asymptomatic people, and I guess the issue is how much weight can the other natural causes hold. I understand your adjustem generis argument, but that's a aid to statutory construction. That's not dispositive.
Well, I think it brings us, your question brings us to the third point, which is if you read the Civil Defense Act, other natural causes to also mean disease and pandemic, though those aren't named in the act, you're going to make the Public Health Act superfluous. The Public Health Act is directly on point with this. The Public Health Act, we say in our briefing, predates the Civil Defense Act by at least 50 years, but in fact, elements of the Public Health Act have been in place for hundreds of years. I mean, this is the one place to go to know what the legislature intended, and what it intended to do was localize disease control mitigation. And also keep in mind too, this doesn't in invalidating the Civil Defense Act state of emergency.
Local boards under the Public Health Act, local boards are going to be able to deal with this issue. I mean, the legislatures, they're there every day. They've been enacting legislation under the understanding that the Civil Defense Act is the means through which this is going to be addressed. And now we're going to look to the Public Health Act and have local boards being able to deal with the pandemic.
Well, that the legislature may be making a mistake and taking the governor's lead in mistakenly believing that the Civil Defense Act applies. The legislature can easily correct its course if it disagrees with the legislature in the early 1900s that put forth the Public Health Act. So local boards of health, if they're actually enabled to do their jobs, they're the ones on the ground. They've been relegated to mere police, health police by the governor's orders. if they're allowed to actually interact the way the Public Health Act intended them to, that is in close concert with each other, because they do form their own coalitions, their own groups in neighboring towns, and getting advice and information and guidance from the Commonwealth's Department of Public Health, this is the path set forth by the general court. And if the general court wants to adapt that, if there are unique dynamics to this particular disease, then the general court can make those changes. There's nothing about invalidating the civil defense state of emergency that would put the general court on its heels. It's already spoken. And if it wants to adapt, it can readily adapt.
Well, go ahead.
No, go ahead.
Counsel, when you say they can adapt, they can adapt. Certainly they could, if they thought the governor was misinterpreting the Civil Defense Act, could not they act now and take care of that?
They certainly could. They just haven't done it.
And you think that's because they're mistaken?
That's right. They are mistaken, and there's no reason why the petitioners should have to wait around for the legislature to come fighting.
Well, let's talk about that for a minute. One thing is, let me ask you, when you say the petitioners waiting around, I understand that this pandemic and the restrictions that have been placed have taken an extreme toll on the people of Massachusetts. Some of them have borne the burden disproportionately in the form of either death or long-term illness, job loss, business loss. Some of the people you're representing would fall into that category. And some have borne a greater burden as essential workers or as Black and brown people who often have the double burden of being the essential workers. Families have been separated. I understand all of that, but bearing in mind all of that, don't you have to admit that Governor Baker's done a pretty darn good job here, especially when you compare him to the other states?
Whether he's done a good or bad job, whether his policies are right or wrong, isn't relevant to the ultimate question as to whether a disease is a civil defense state of emergency, or to the question as to whether he can exercise the general court's police power by issuing his orders.
And so, related to that, if the legislature did not think he was, they could amend that, but you say he's mistaken. Would you be happier if, say, they amended the statute to include the word pandemic? Would that be okay?
If the legislature amended the statute to include pandemic, that would probably be a signal that the legislature meant for the Civil Defense Act to supersede the Public Health Act in these circumstances. So yes, but it doesn't provide for that now.
Okay, and one other question on that front. One of your other arguments is about duration, that, floods, fires, even the gas explosion was of a limited duration, and that this could go on and on and on and on. What if some of those natural disasters did take, say, 9 months? Maybe we have a 9-month forest fire, or we have a chemical explosion that leaves. Would they be out? Would we be out of luck too? Would we have to wait for the legislature to take control of the situation?
Well, I think the issue there, well, certainly those examples would definitely fit within the Civil Defense Act.
But they'd still be of a long duration, and you say things of a long duration are not contemplated.
Things of a long duration, that is, let me try to rephrase it a little bit. It's about the impossibility or the substantial impracticality of the legislature being able to meet. I mean, this is supposed to be a bridge. Emergency powers are a bridge from one end to the other to get Massachusetts through crises such as the one that you're raising here hypothetically. And so
how long is a reasonable amount of time for an emergency?
That is certainly by a case-by-case basis. I don't think you can put a definitive time on it.
All right. Now, one other thing, and then I'll turn this over to my colleagues. Well, two things. I think Justice Lowy asked you this. Do you really think that numerous local health boards can control a pandemic that spreads like this?
That's not for me to decide. The general court believes that. And the general court believes that, including, smallpox and all other diseases.
So you're not going to register on that because that's not within your territory. Is that correct?
I'm sorry.
You're not going to tell, you won't say whether you think they could do it because that's not within your authority to make that judgment.
It's also not within my competence. I'm not a healthcare professional like the local boards of health consist of healthcare professionals.
And then I have one more question, and I'll be finished. And that is that we're a Commonwealth, and when that's defined, it means public welfare, general advantage, and that dates way back to the 15th century. There's all kinds of restrictions we endure gladly for the common good. Traffic laws, you have to wear clothes, regulations on certain kinds of business. We don't have total freedom so that we can be protected from one another. Doesn't this pandemic provide a really good example of why that is? That some people have to put up with some restrictions for the greater good.
Oh, absolutely. And let me make it perfectly clear, if I haven't made it clear yet, the petitioners have been doing their part. They will always do their part. They have abided by the governor's orders as best as they could understand the governor's orders, and will continue to do so as long as this court decides that they are in fact lawful orders. And
They
so,
just want it to come from the legislature.
this is an issue of process and what is the character of Massachusetts government. Is it a government of laws or a government of men? That's the key question here.
We have a question from Justice Kafka, and then I believe Justice Link after Justice Kafka.
So I'm trying, I've read both statutes carefully at this point. So I'm trying to understand if we disagree with you that the pandemic is a natural cause, were all the governor's actions then justified? Again, I understand you disagree with that point, but if we felt that the pandemic is a natural cause, did he exercise his powers properly?
Well, so in that circumstance, I think there's still problems with a number of the orders. It wouldn't be all of the orders. So if this is not a civil defense emergency, all of the orders fail. If it is a civil defense emergency, many of the orders fail, and we have a chart, a graph attached to our reply brief to identify those where the governor has unlawfully dispensed with the law and violated due process, and where he has violated the right to assembly.
Give me one example. I'm just trying to understand again. I understand.
Okay.
If it is a natural cause, give me one example where he's exceeded his power.
I think one example that we used, I was just looking for one here on my screen. I don't see it, but one we used in the briefing was, I believe it's Order 45, the travel ban. The Public Health Act clearly states that border towns, local boards of health can prevent travelers coming from out-of-state infected areas from traveling through Massachusetts. They can even get a warrant to forcibly quarantine or remove that person from Massachusetts. And so when Governor Baker says, no, now the Civil Defense Act, I've got the power, he is obviously supplanting the legislative will that it would be the local boards of health that would control that. And again, they are working with the state on this thing. It's not that they're completely independent. They're still.
I'd like to switch to the other statute for a second. So again, the powers here, there are 294 towns and 57 cities in Massachusetts. So your view is that we've got all these different actors dealing with a public health crisis, and that's what is meant to be occurring here. Is that?
With coordination, I think the Public Health Act is clear that all this must be coordinated through the Commissioner of Public Health. And indeed, Commissioner Burrell has been doing that. The problem.
So if the commissioner were doing what the governor is doing here under the Public Health Act, could the commissioner do all of that?
The commissioner couldn't do all of that. The commissioner could do much of it.
What could the commissioner, what could the governor do that the commissioner cannot do under your view?
The commissioner couldn't suspend the law. So the Civil Defense Act allows for suspension, which is different from dispensation with the law, but suspension of the law, if this is a legitimate civil defense emergency, the governor, take something different like a hurricane comes through. The governor can suspend the law and say, okay, all businesses, so everyone's treated equally, all businesses, all churches, all schools, everything is closed until this emergency is over. That's not a power that Commissioner Burrell would have with Governor Baker's public health emergency. That's different.
Could the commissioner shut non-essential businesses under your view under the Public Health Act?
No, I don't believe the commissioner could shut down non-essential businesses because the commissioner wouldn't have the authority to identify what businesses are essential or not. I think the commissioner could perhaps provide guidance to local boards of health for occupancy standards, keep six feet away, in stores people should be wearing masks, and those sorts of things. Commissioner Burrell has also allowed for compounding of hand sanitizer in pharmacies. So this is the ordinary course of things when using the Public Health Act to protect people from infectious disease.
My last question is trying to distinguish between these two acts. It seems to me that the Civil Defense Act is meant for basically when all hell's breaking loose out there. And the Public Health Act is dealing with, I mean, again, we have health problems constantly, we have disease outbreaks constantly, but it's a level of magnitude where these two statutes differ. Is that not correct?
I think it's correct that that there is an element of magnitude to these, since the Civil Defense Act is all-encompassing. I mean, Governor makes it clear in his briefing, and in that sense, he's correct that he has a tremendous amount of power. Not the power to do anything, not the power to dispense with the law, not the power to obviously violate constitutional rights. But he does have a lot of power, and that's because the statute itself contemplates a very real cataclysm. And that's entirely different from the Public Health Act, where the Public Health Act contemplates that, yes, there will be epidemics. There are ways to control these and still look out for people's civil liberties. There is a way to do this and to do it simultaneously.
Justice Link, I believe, has a question.
I do. I wanted to ask you about legislative history as to each of these statutes. Do you have anything that you can offer in terms of our statutes? And also, in terms of the statutes for the states and decisions in this regard, that I'm sure that this is not the only challenge that your organization has brought, or organizations like yours have brought. So could you tell me what's going on in other states and what the results have been there?
Sure. There are very few states that have the same dynamic of a Civil Defense Act and a Public Health Act that are competing. As a matter of fact, just the other day, there was an argument before the Michigan Supreme Court in which the argument really centered around two separate emergency acts and then the interplay with a Public Health Act. The difference was one of those emergency acts allowed the governor to act in the event of infectious disease. So the dynamic was a bit different because there was true overlap between those statutes. We've seen in, I think it's important to bring up the McCarthy case, the McCarthy against Baker, where I believe it was District Court Judge Woodlock had ruled that Governor Baker's orders closing gun shops was unconstitutional because it wasn't related to the larger needs of protecting in a pandemic. There are a number of other states that have basically given away the farm. Rhode Island is a good example. Rhode Island has a military defense act that allows a governor to, similar to Governor Baker, establish a civil defense state of emergency. But in that act, the legislature had included the word disease, had included epidemics, but of course that includes pandemics in it as well. And so it's a bit of a hodgepodge across the country. And so it varies depending on where you go. As far as your question regarding statutory history, certainly the Civil Defense Act, having been enacted in 1950, was really the product of prior war acts and military preparation during war. And in fact, there is the one case that we cite, I can't remember the name of it off the top of my head, where, actually, it wasn't a case. It was an attorney general's opinion that explained that the governor under the prior war act may have the authority to build a bridge to help the war effort in World War II, but the governor wasn't allowed to determine what the scope of that was, what was an emergency. He knew that the emergency was World War II. As far as the Public Health Act is concerned, as I mentioned a few moments ago, this dates back at least 50 years in the form in which we see it today. But it goes back hundreds of years. I mean, Massachusetts has dealt with smallpox, has dealt with a number of diseases.
Not pursuant to that statute, you're saying. Not pursuant to the statute. They've dealt with it, but it hasn't been pursuant to the statute. The statute was enacted only 50 years ago, you said, right?
I'm afraid I don't understand.
The Civil Defense Act. When was the Civil Defense Act? Civil Defense. That was 1950. When was the other one enacted?
Well, it depends on how you measure it, but about 1903 to 1909, and it really dates back to the 1800s.
You have a statute that dates back to the 1800s?
there are provisions that have been adapted and modified back to the 1800s to bring it up to, that's why I choose to say it was about 1909, because that's the modern approach that we see and how it was codified in Massachusetts general laws. So
You see these statutes as being in conflict with each other, or one being narrower or broader than the other, or what?
they're only the governor's interpretation here brings them into disharmony. Otherwise, they're perfectly harmonized. The Civil Defense Act, there are only seven triggering events, 7 triggering cataclysms, whereas the Public Health Act is a general law meant to protect Massachusetts' health and safety at all times, which is why we have people, healthcare professionals on the ground in their communities who understand their community's needs best of all and who can react to changing environments in real time instead of having to wait the delay of certainly a single person, the governor, trying to adapt as a dynamic disease progresses through society.
Justice Seifer?
Yeah, I just have a few more follow-up questions after listening to some of your answers. You spoke, I think it was in answer to Justice Kafker's question, or maybe it was Justice Link, about Rhode Island, and you were comparing their statute, and it sounds like their statute is broader than ours. Is that right?
That's right. They had amended it. I forget exactly when, a handful of years ago, I think within the last 5 years or so, they amended
it. Includes disease?
Include disease, right. It did not.
In response to that, you referred to that as giving away the farm. Can you explain what that means?
In other words, I would question whether the whether any legislature in any Republican form of government with any semblance of separation of powers can divest itself of its core legislative responsibility to legislate the police power, the health, safety, welfare.
So actually, the problem then is not that the statute that we have doesn't say disease; it's that it's a delegation of police power that's too much in your mind.
It's both. This statute doesn't say disease. And even if it did,
it'd be too much. All right, now suppose we agree with you. Suppose we say, you know what, you're right. This is the legislature's prerogative, and then they don't do anything. What happens then?
Well, then it seems that the legislature would be communicating that, hey, we like what the, I think I forget which legislature, 128th or whatever it was. We like what the legislatures had done, and by the way, consistently amend the Public Health Act throughout time.
Well, going back to that then, the Attorney General Healy's office has argued the legislature has demonstrated its approval of the governor's interpretation of the CDA by funding the initiatives and by not curtailing the power. Isn't that the same point you just made?
I think that's related to the ratification argument, and it's not, all right, maybe I misunderstand the question. So if the argument is the legislature has indicated its approval, and that's not the role of the legislature. The legislature, by the way,
it's their role to delegate, and they can decide what they mean by a statute, right?
They certainly can, and this court's been clear that the delegation must be limited to filling in details. It can't be the establishing of policy.
All right, and so if the legislature thought that the governor wasn't filling in the details right, wouldn't they do something?
Well, I would like to think they would do something, but they might not do anything. The governor has taken control, and he's turned the government upside down. I mean, at this point, the legislature is left to approve or disapprove of the governor's policy choices. That's not how it's supposed to work. The governor is merely supposed to execute the policy choices of the legislature. And for the legislature to make a change, the legislature would also have to have a veto-proof majority in order to do so. That is standing the government on its head. That's not a Republican form of government.
Okay, I think I understand your argument.
I think we have a question from Justice Lowy, then Justice Kafker.
Thank you, Justice Gaziano. I just want to turn to the constitutional issues for a moment. And obviously, we're looking at Jacobson versus Massachusetts. And we're in that situation, one of the points that you make is that the smallpox vaccine back in 1905 was pursuant to legislation. And here, the governor is acting, you say, without legislative authority. And so that's a distinction from Jacobson. But in South Bay Pentecostal Church, with Chief Justice Roberts' concurrence, when he was looking at the constitutional issue involving a limitation on how many people could worship at the church, he was addressing an executive order. So if we're going to look at legislation, executive order, here we have a situation where, at best, you're saying that the governor is acting beyond the delegation of the Civil Defense Act. So that's a long way of saying, how can you put so much weight on your constitutional analysis in Jacobson and reconcile it with Chief Justice Roberts' concurrence?
Well, because it's still the governor's argument that there is some lesser rights available to people during time of pandemic is simply wrong. And so I think the way we reconcile Jacobson with Chief Justice Roberts' opinion on the matter is that Jacobson still required the government to meet some sort of level of constitutional protections. There's got to be some indicia of defense of civil liberties available. And so it doesn't necessarily mean that in having due process, there must be a hearing where someone may be vocally heard, but there's got to be some sort of process here. I don't think, unless I don't remember the Chief Justice Roberts' opinion correctly, there wasn't an issue where the governor was simply had his own counsel and the executive then issued an order, and that there was no process whatsoever to seek reclassification.
So I understand. I'm not sure I agree with you, but I understand your procedural due process argument in that regard. I understand, and maybe we'll have time to get to it, but I'm not talking about the procedural due process analysis. I'm talking about the substantive due process analysis and looking at whether it's strict scrutiny or whether it's rational basis. We see that Jacobson was in perhaps similar circumstances, okay, and you've got your argument to differentiate Jacobson involving, well, that's the governor acting as opposed to a legislative mandate. And what I'm saying is, in Pentecostal Church, Chief Justice Roberts' concurrence is an executive order. So I'm not asking at all in this question about procedural due process.
Okay, I'm sorry, I misunderstood. So Chief Justice Roberts wasn't examining Article 10 of the Declaration of Rights that requires standing law. It says that only standing law can regulate and burden due process rights. And so Governor Baker's orders can't be considered standing law. Even Governor Baker wouldn't argue that they are standing law. They are executive orders. And because they're executive orders, and again, they don't have any of the features of due process that you'd expect with a standing law. We don't have the confidence, unlike a standing law, where I or any one of the petitioners can reach out to a legislator to try to influence law. Whether that works or not, at least we understand where that law comes from. And so perhaps in those circumstances, substantive due process deserves lesser scrutiny, perhaps in those circumstances. But there's been absolutely no process here whatsoever similar to that, similar to the creation of a standing law. And that's ultimately the problem, and ultimately why I think Governor Baker has to be held to a strict scrutiny standard.
Justice Kafka?
But doesn't, again, it all assumes that the legislature doesn't think the pandemic is a natural cause, right? Because the legislature, if it does think the pandemic is a natural cause, has expressly authorized the governor to act. Also, it reserves in Section 22 the ability to withdraw the power, and it's not done that. It's also has its continuous ability to pass laws, which it's done for the elections and other things during the crisis. So again, doesn't this all hinge on the fact that you don't think a pandemic is a natural cause under the statute? Otherwise, the governor's actions are clearly provided with legislative authorization, and also, as Justice Cypress says, confirmed by the legislative inaction or its responses so far.
Well, certainly the first step in the constitutional analysis of our separation of powers argument is, yes, statutory interpretation. Disease can't be another natural cause, because then there's no limitation. Then every natural cause presents a civil defense state of emergency potential.
Every natural cause that's a natural disaster, basically. It's not every time someone gets sick in Massachusetts. It's a pandemic that threatens our entire way of life.
And the Public Health Act is there to prevent that. And again, I must stress this, that it's not the job of the legislature to approve or disapprove of what the governor's policy making is, and the governor's choice to use the legislature.
Counsel, you call it policy making, but I think Justice Kafker might call it interpretation or application. It's a little bit different, isn't it?
I don't see the difference, since, I mean, just the looking at essential and non-essential businesses, making that judgment. These were lawful businesses before March 10th was a declaration, and then a couple weeks later was order number 13. But that is the responsibility of the legislature to take that up. The legislature can make those choices. The governor may not. That is a clear policy choice, deciding who is or is not essential. And in the meantime, not taking into consideration any possible exceptions, any way for any of the petitioners to ask to be recategorized, to ask for appeals, to ask for waivers, or anything of the sort. If the legislature was involved, they would be able to influence their legislators.
I thought he had a lot of boards from representatives of all the industries and the interests and the hospitals and the schools and the businesses advising him.
These are not elected representatives of the people. I'm sure that those organizations.
People
could still go to their elected representative, though, can't they?
They certainly can, and they have been. And
Mr. DeGrandis, I take your point that it's actually our job to determine whether or not the governor's orders exceed lawful authority, correct?
Correct.
All right. But as Justice Kafker indicates, and I'd like to hear your answer to this, maybe again, as he indicates, if we determine using tools of statutory interpretation that the Civil Defense Act natural causes includes the pandemic, the fact that there's another statute doesn't bar that interpretation. In essence, if there are two statutes the governor could have used and he picked one, that's not unlawful, correct?
Well, that would be correct, although it should inform your decision as to whether he made the right decision in the first place.
Well, that's policy. The statutory intent, legislative intent policy that you posit is that the Public Health Act is properly the vehicle to address a pandemic.
Right.
But if we don't agree with you and we think that the natural causes language in the prior act controls, it's up to the governor. If both are applicable, he can pick either, correct?
I don't think so. I think to the extent that, so let's take that hypothetical, or not exactly hypothetical, let's assume for the sake of argument that you decide that either one could work. Well, to the extent that then
either one is lawful, right? His authority is lawful under either one, correct?
Right. So let's say lawful under either one. The civil defense component of the Civil Defense Act is the only portion that he could use with respect to civil defense issues. He would still need to effectuate the legislature's will with respect to the Public Health Act in getting Massachusetts healthy again, in monitoring and controlling the spread of the disease. I don't know where that dividing line would come in, since it strikes me that these are two profoundly different acts, but there would definitely be a dividing line there, because there could be a blended circumstance, not in this particular case, but in another type of disaster, perhaps.
Thank you. So let me just make sure Justice Kafker is done with his question. I know Justice Link has a question. You all set, Justice Kafker?
Mm-hmm.
Justice Link?
I'm all set, thank you.
Okay. Any further questions for Mr. DeGrandis?
No, thank you.
Thank you, counsel.
Thank you.
Mr. Martland.
Good morning. May it please the court, Douglas Martland, Assistant Attorney General for the Governor. If I may make one brief response before addressing your questions in relation to Mr. DeGrandis's argument. Here, the governor is appropriately acting within the bounds of his authority delegated to him in the act. There are three limiting principles. The first is judicial review. All actions remain subject to judicial review for under an arbitrary and capricious standard. The second is the act itself. The declaration of emergency must fit within the statutory definition, a broad definition, and each order must reasonably relate to the emergency. And we can talk about in a few minutes why that's the case here. Third, we look to the legislature, whether there has been approval or disapproval by the legislature. And again, we can talk about whether there has been here, but I think the facts are clear that there has been a repeated confirmation, ratification, and appropriation by the legislature of the governor's actions here.
But number one on your list always exists in every legislation, so that doesn't answer the question. And as Justice Gaziano just pointed out, number 3 on your list doesn't help because it's not for the legislature to affirm the constitutionality of the statute or the interpretation of the statute. So it's really about legislative intent from the Civil Defense Act. And I guess the question is, if there's going to be this delegation of this type of enormous power, shouldn't the authorization in the statutory language be clearer than this, as opposed to in Section 5 and subsection 5, we've got floods, we've got earthquakes, and all of a sudden fires, and then we have other natural causes. Isn't other natural causes in any way limited by the other 3 circumstances? Again, I'll repeat, especially when we're dealing with an enormous delegation of power.
I understand that, Your Honor, and the only commonality between the various disasters and catastrophes that are listed in that phrase is that they are disasters of massive proportion that dramatically affect the people of the Commonwealth. And the pandemic clearly falls within that. It arises from a natural cause, a fact that's undisputed in this case, and it is causing a disaster of massive proportions within the Commonwealth and across the country.
Just like.
What about the flu pandemic in 1918? Was that not a massive public disaster? Was that not dealt with under the civil? That was not dealt with under the civil side of it. Of course, that didn't exist at the time. But the question is then, what part of the Civil Defense Act would it come under? The other causes, natural causes?
Yes, Your Honor. We certainly agree that the 1918 flu epidemic or pandemic, if the Civil Defense Act had existed at that time, would clearly fall under the other natural causes language. How
about the polio? How about the polio epidemic?
And I think there are several factors here that are highly relevant to distinguishing the two, Your Honor. The first is that in both the 1918 epidemic and again today, we're dealing with a novel virus to which no playbook exists for how to combat it. The second,
polio, that was true with polio as well, wasn't it?
To a degree, Your Honor, yes, but it was not nearly as highly contagious. It was not overwhelming public health systems. It was not causing the scale of deaths and destruction that it is in this instance. And it was certainly reasonable for the governor to make a decision that it falls within the other natural causes language. Right?
But he didn't in those instances. In polio, he did not, did he?
I do not believe so, but prior governor's decisions whether or not to act under the Civil Defense Act certainly shouldn't determine whether this particular circumstance falls within the Civil Defense Act.
Well, let me just make sure Justice Lowy finished his question.
Well, I have some constitutional questions to ask, but I'm going to wait until the statutory interpretation is done.
Okay, so we have Justice Seifer, then Justice Kafka in order.
Okay. With regard to the statutory interpretation and the examples Justice Lenk raised of the flu pandemic and the polio pandemic, those one occurred definitely they were before the Civil Defense Act was passed. But now, considering where we are today with regard to international air travel, the speed of automobiles, how fast everybody's moving around, do you think that the statute needs to be amended to take it into account the modern situation?
Your Honor, the statute does not need to be amended for the governor to have authority in this instance. Again, this is a disease or a virus that arises from a natural cause that is causing destruction and damage on the scale of the other disasters listed in the phrase fires, floods, and earthquakes.
Okay, may I ask one follow-up on the statutory interpretation? Your brother had argued that there should be a limited duration involved in this. What do you say to that, and what do you think is a reasonable amount of time for handling an emergency?
I think, Your Honor, that it depends on the circumstances. Here we have, if you look at the broader statute as a whole, we have the inclusion of the term war in the statute, which is inherently a long-lasting conflict. And certainly we can draw the conclusion from that the legislature did not intend duration in the potential duration of a pandemic or of an event to determine whether or not there should be a civil defense emergency. And again, I would come back to the limiting principles here that during the course of any civil defense emergency, it of course remains subject to arbitrary and capricious review of whether the emergency remains ongoing. But what we shouldn't be doing is using that duration to cut off an emergency that we're clearly in the middle of right now.
Justice Kafka.
And my questions are the same. How we do the legal analysis under the they follow up on Justice Cypher's last questions. How we evaluate the governor's powers over time. I mean, we started in March. It's October. You know, we're working towards October. The legislature hasn't changed its response, but does the governor's power remain sort of at that level of deference as we move, you know, later into the process, a year or two? If we don't get a vaccine for 2 years, how do we analyze that legally? I understand it's factually dependent, but because the statute clearly has an emergency time component to it, are there cases guiding us on how to deal with the passage of time?
Certainly there are, Your Honor. I would point you to two things, one in the statute itself, and then a specific case from this court. In the statute itself, you can look at section 22, the sunset clause. When that was originally enacted by the legislature, there was a 2-year limitation on the operation of the Civil Defense Act. Over the next several years, the legislature removed that, again indicating that it did not intend duration to be the limiting factor of the emergency. I'd also point this court to the Director of Civil Defense case from 1977. In there, the court was evaluating a 1962 executive order. So at the time of the decision, it was 15 years old. And the court didn't blink at the age of the executive order and its continuing operation. And two reasons for that, and this circles back.
What did that executive order empower the governor to do? I take it it's nothing like this level of authorization, is it?
Certainly in a comparison to scale, that is correct, Your Honor. Mm-hmm. But in that instance, the court was untroubled by the duration and looked specifically to the legislature's actions that it had taken in relation to that order. And there, the legislature had practically ratified the governor's actions in two separate ways. First, it had confirmed it by continuing to provide the funding for the various employees. And second, it had appropriated money to do that. And again, that's exactly what we have here. We have the legislature confirming and ratifying the governor's decision in a host of legislation that's cited in our brief. That includes the declaration of emergency being a contingency for the operation of the statute. We also have the legislature appropriating over $1 billion in funds to the Commonwealth's COVID relief response. And if the legislature had any indication of disapproving, certainly this court could conclude that they would have done something more than that.
Delegation is a legislative intent issue, but ultimately, as I said previously, it's our call as to whether or not this is lawful, correct?
We certainly agree that this question is subject to judicial review, Your Honor.
Okay, let me ask you a different question. Can you address the whole concept of constitutional winners and losers, and more specifically, the impact of Judge Woodlock's Second Amendment decision in the federal court?
I think this court should look closely, Your Honor, at both Jacobson and the recent federal decisions that interpret Jacobson as applied to this current pandemic and governor's orders in those cases. Those cases make quite clear that the court's role here is to approach any order with broad deference as to the governor's interpretation. And the reason we do that, and this court specifically talked about that in slightly different context in the American Cancer case, is because the governor is in the best position with the most contemporaneous knowledge to deal with this emergency. The governor has all the information that the legislature just doesn't have at its fingertips. And that Chief Justice Roberts said that in his concurrence in South Bay, and it's been a theme that's been repeated throughout all of these recent federal court decisions.
Justice Slowey.
Yes, along those lines, I want to ask you about order number 46, which, as you know, deals with the exemption for outdoor religious gatherings and for protests. And the petitioners are making the point here that that classification, that exemption, seems to be arbitrary, and also that there seems to be a distinction that may raise issues about whether or not there's an expressive content concern with that exemption for protest and religious worship. And even putting aside whether we're dealing with strict scrutiny or a rational basis, we're dealing with a right to assemble. And we're dealing with an issue where we have concerns about overbroad or even under-inclusive. Is there a problem in time, place, and manner with Order 46 that might be different than some of the other orders here?
There is no problem with Order 46, Your Honor. Just like all of the other orders, it's a content-neutral, generally applicable order that applies to everybody. What the governor has clearly done here is try to identify specific circumstances and then address the public health implications of those circumstances. And the orders leave ample opportunities for alternative avenues of communication, and they have also attempted to accommodate, as best that can be done during this pandemic, the core First Amendment rights of all of the people of the Commonwealth.
Justice Slate.
Oh, I didn't have anything, thank you.
Oh, I'm sorry, I thought you raised your hand, I'm sorry.
No.
Any further questions? Justice Slowey.
Yes, could you just address the issue? You say that all of the harms that the petitioners raise, they're too general, they're not specific enough. I don't mean to point out the one that is the most specific in response to that argument, but the owner of the tanning salon lays out with some precision what the harm is, that we need a narrow tailoring and an appropriate government interest. We obviously have the appropriate government interest. I don't even think that's contested. But as far as narrow tailoring and the harm, at least address that one plaintiff.
Certainly, Your Honor. Two responses. The first, I believe that we acknowledge in a footnote in our brief that a plaintiff like that who has alleged specific harm certainly has standing, the first part of your question. answering the second part of your question, both Jacobson and Chief Justice Roberts' decision in South Bay make clear that these difficult and challenging line drawing decisions are best committed to the executive official who's publicly accountable to the people, as opposed to courts that should be giving broad deference to these decisions. And within that framework, it was perfectly permissible here for the governor to make a difficult line drawing decision as what entities should be open during what phase. And certainly the plaintiffs or the petitioners here can challenge any of these individual determinations on an arbitrary and capricious standard, subject to judicial review.
Justice Seifer, and then,
Yes,
and then Justice Link.
Oh, I'm sorry, me?
Justice Seifer, and then Justice Link.
Okay, thank you. I'd like to just have you address, Attorney Marland, your brother's argument that actually the local communities are better placed to regulate their local businesses through their boards of health because they know their communities. For example, if somebody lives in a very rural area, the needs might be different than somebody who lives in a more urban area, and that it's actually the local boards of health and the local leaders of the community who are better in touch with that.
Certainly, Your Honor. And the answer to that question is that in this instance, the Commonwealth needed every tool that it had available to it to deal with this pandemic. Certainly, the local boards of health represent one level, but they cannot provide the coordinated state-level response that is necessary to combat the pandemic in Massachusetts. Their authority does not extend to many of the factors, including expanding healthcare capacity, regulating certain licenses and things like that, that are absolutely essential for the Commonwealth's response.
Justice Link.
I just wanted to make sure that I understood the governor's position here, which is that I gather that he felt that he could have used either of these statutes in order to act.
The governor's position is that executing his authority under both statutes was necessary because of the pandemic itself and all of the.
Say he has exercised it also under the other statute.
Yes. If you look at the declaration of emergency from March 10th, he makes the declaration under both the Civil Defense Act and General Laws, Chapter 17, Section 2A. And the governor's position is that all of that authority was essential because the Commissioner of Public Health Authority does not extend to far enough to respond to the pandemic.
Okay, thank you.
Any further questions from Justice Lowy?
Just one last question. I think the petitioner's main point is that they believe that the governor is picking winners and losers here, and that putting aside whether or not the legislative mandate's available. And one of the examples has to do with, for instance, well, how do you distinguish between the risk of the pandemic in an arcade as opposed to a casino? And what's the rationale for something like that allows one person to pick winners and losers? What's the response to a constitutional argument that it's just arbitrary and it's just drawing lines with no rational basis to it?
Well, certainly, and there's two answers to this question, Your Honor. The first answer is that the line drawing here was not arbitrary. Casinos are highly regulated with by the State Commission. They're well resourced, and they're in a position, both with cameras and security, to attempt to ensure the public health of their patrons. There are also only 3 casinos across the Commonwealth, and they're in relatively new buildings. By comparisons, there are a host of arcades across the Commonwealth. They are generally in poorly ventilated buildings, and there is no state oversight commission for arcades to impose any type of workplace sector regulation, which we've seen the governor here establish by the state established by regulation. The second answer, Your Honor, is that in Order 50, which was issued yesterday afternoon, the governor moved up arcades into phase 3, and they're going to be able to open, I believe, on September 17th, once the workplace or the sector-specific standards are in place for arcades.
Justice Kafka.
there's a no damages provision, right, under the Civil Defense Act, right? So the governor has these terrible choices he has to make here, but there's no way to and we owe him, I take it as you say, deference on that decision making, but some of the decisions are gonna not be 100% correct, right? But there's no way to compensate anyone for that, right?
That's unfortunately correct, Your Honor, yes.
That's the really difficult part of this, that, you know, as Justice Cypher began, there are a lot, you know, we're all in this together, but some people are suffering much more than others, and there's no way to correct that, right?
Well, I think that's a situation, Your Honor, where you have to look to the Commonwealth's broader response to the pandemic. One of the statutes that the legislature passed during this was the expansion of unemployment insurance. And certainly that is, you know, account for in part the effects of what's happening in relation to the pandemic.
Thank you.
Any further questions? Any further questions? Thank you, Mr. Martland.
Thank you both.
Thank you.